Welcome to Canton Confidential. I'm Glenn Jones. Thanks so much for being with us. In just minutes, you'll see the first on-camera interview with a member of the Karen Read jury. He's from the first trial, which ended in a mistrial. Before we get to that, though, as we near the second trial, there are last-minute procedural matters to resolve. That's why both sides were back at Norfolk Superior Court today. Our John Maroney was there.
I like talking. I like to reveal the truth.
A gag order on Karen Read's attorneys. Prosecutors are asking Judge Beverly Cannoni to put one in place.
The ongoing, deliberate, purposeful poisoning of the potential jury pool is not only wrong and unfair, it needs to be stopped.
It wouldn't apply to the 45-year-old defendant who's pleaded not guilty to hitting and killing her boyfriend, John O'Keefe, with her SUV.
You say anything about a possible gag order? How would you like that, counselor?
Michael Proctor prompted the request after the defense released a text message, apparently inadvertently, from the embattled state trooper, despite court orders to the contrary.
It just did not register with me. It got by me.
The defense is asking to keep a dog bite expert for the state off the stand, arguing Dr. Stephen Crosby isn't qualified to offer a medical opinion about the scratches on O'Keefe's arm. Read's attorneys say they were caused by a dog, part of a conspiracy to kill him. The prosecution has called the suggestion absurd, saying its expert is qualified and has taken a mold of the dog's teeth.
There is no requisite that an expert in this field needs to be a medical doctor.
The federal investigation into John O'Keefe's death has never been confirmed until now, with the Canton police chief releasing his statement saying in part the investigation is no longer active and will be closed.
There is no longer any federal investigation into the investigation of John O'Keefe's death or any related matters.
There are two hearings set for Wednesday. One of them will take place here at the courthouse in Dedham. The defense is set to argue its motion for dismissal. The other is at the federal courthouse in South Boston. Karen Read's attorneys are challenging the SJC's recent ruling regarding double jeopardy. In Dedham, John Maroney, NBC 10 Boston.
Okay, John, on a busy court week like this, we like to turn to our NBC 10 legal expert, Michael Coyne, who joins us remotely tonight. Michael, good to see you. Let's start tonight where Judge Beverly Cannoni started. She prioritized this in her hearing. Here's what she said after laying out the agenda this morning.
You all know that when one of you speaks, you speak for the entirety of the defense team. When one of you acts for the entirety of the defense team. And when one of you makes representations or misrepresentations, you speak for the entire defense team. You all know that. Do you understand that, Mr. Kennedy?
I do, Your Honor.
Mr. Jackson?
Of course.
Ms. Little?
Yes.
And Mr. Alessi?
Yes, Your Honor.
All right, Michael, you need to be the judge whisperer for us. It seems like Judge Cannoni was kind of clapping back on the argument by Read's legal team last week. They were arguing that they did not need to disclose payment on those two accident reconstruction experts during the first trial. We know something about all of this gave Judge Cannoni those grave concerns. That was the big quote when they met the last time. So should we take all of this to mean that she's leaning toward punishing those defense attorneys?
I think that's the correct assessment. What she asked about today, again, is still on her mind. Were there misrepresentations and misstatements made to the court with respect to the accident reconstruction experts? And she still hasn't got the answer that she's looking for. She asked Attorney Alessi, you said you inferred there were no further contacts. Were there any other contacts between the accident reconstruction experts and counsel? And he said he didn't know, and no one from the defense table answered that question. And I think that's a very, very telling remark that the court is going to put a lot of weight in. She wants to be assured that the actions that were done were not done with the intent to mislead the court. I don't think she got satisfactory answers to that today.
All right, we heard about some other experts during the hearings today. It was questions about the qualifications of two of the prosecution's potential witnesses. That's Dr. James Crosby, the dog bite expert, and meteorologist Robert Gilman. Now, the defense wants those guys thrown out. They sound like experts to me as a layman, Michael. How does the judge decide when an expert can indeed testify?
Well, she looks at their background, education, experience, and training, and to see if that testimony then will aid the jury's understanding of the event. I think, as you point out, the experts certainly appear to be qualified by background, education, experience, and training. And the question really, I think, will come down to specific questions that will be posed to the experts that will be within their area of expertise, and they'll be allowed to answer. I think at the end of the day, she is likely to allow both experts to testify to certain questions that the prosecution asks, and then allow the defense to clear up whatever matters they have on cross-examination.
Okay, expert witnesses are just one part of what they have to sort out before the trial begins. A lot more to get through. Michael Coyne, same place, same time, same channel tomorrow, please. We'll see you then.
See you then, Glenn.
All right, thanks very much. As we look towards the second trial, we are also getting new information about how Reed's first trial ended from someone we haven't seen until now. One of the 12 people who sat in these chairs listened to all the arguments, only to have the trial end without a verdict. That juror speaking to our Eli Rosenberg tonight.
Kind of overwhelming at first, and then it got very interesting, and then at the end, kind of disappointing.
You had this front row seat. What do people not understand?
It's difficult for some of the public to understand why we arrived somehow to our conclusion, but it was totally based on the evidence that was provided to us and that we could actually consider.
At the time, there were a couple things during the trial that were a huge deal as it happened on the outside, and I'm wondering, did it resonate with you? One being the testimony of Michael Proctor, the lead investigator, and those texts.
It was very surprising. It was very unprofessional, and at that point, most likely we would discredit or not consider his testimony as strong.
Another big thing was this Google search. How's long to die in the cold?
We didn't believe that there was enough evidence or expertise to kind of indicate that it was reliable. It did not appear, at least to myself, that she intended to commit murder. The other piece, which was the leaving a scene of an accident, also did not appear very clear, and therefore everybody voted for those two charges as not guilty. That second charge, that was the one that was very debated in terms of whether ultimately she did it, became questionable. And now that is where there was reasonable doubt in some minds. Unfortunately, we didn't get clarification early on that we could look at each charge individually and independently of each other. If we had done that, then I don't know where we would be or if we would be talking today.
Do you think there was going to ever be resolution on that second charge?
I honestly believe that there would not have been any resolution because some people had very good arguments, and at that point it was just trying to convince people and change people's beliefs, which would not be possible.
Our thanks to Eli Rosenberg for that important interview. Eli will have part 2 of his conversation with that juror coming up tomorrow, including his advice for Karen Reed, her lawyers, and for prosecutors as the second trial is set to start next month. Well, let's bring in our courtroom insider, Sue O'Connell. You were just listening to those comments from Ronald.
Yep.
And I know every day that you sat in that courtroom, we would ask you to try to read the body language of the jurors to let us know what they were thinking. Now that you've actually heard from one of them, and you can see him as he's talking, is there any gap between what you thought you were seeing and what he was actually saying tonight?
No, and he was in the front row. I don't know if Eli knew that. I can actually see some nights I dream about the jurors. I saw them for 40 days staring right at them. I kept referring to him as one of the technical jurors, meaning that when there was technical testimony, he would perk up and pay very close attention. He paid attention the entire trial. Not for one moment did I ever think that he was not paying attention, gazing off,
so very
daydreaming.
studious.
Yeah, he was really paying attention, but during technical data, he leaned forward, he took notes, and he was riveted. And unlike some of the other jurors, he didn't seem to have any of the side talk or joking that they would when they would come in and out of the jury, which they're allowed to do. I'm not being critical. But he seemed very mission-focused during the entire trial. So I'm not surprised to see that his background shows that he actually has a technical job, and he was very, very thorough about what he evaluated.
Sounds like the kind of juror a prosecution would want to see there in the panel. All right, speaking of the prosecution, we should highlight a point made today by Special Prosecutor Hank Brennan as part of his call to sanction the defense. Let's take a listen.
Consider the history of efforts by the defense in this case to disseminate information or to make statements that should not reach a prospective juror before this jury trial starts in less than a month. Now, after they disseminated this information, it wasn't within 24 hours. It was within 24 hours. This was in the local news, the national news, newspapers, online, and it seems that was the very purpose it was spit out into the community. And so the Commonwealth's position is there needs to be a sanction to stop violations of protective orders and violations of the rules of trying to convince the public before trial about a certain side's position.
Bottom line here, Sue, is that Hank Brennan is asking the judge to put a gag order on the defense. And listen, everything around this trial has been very loud, not only in the courtroom, outside the courtroom, on social media. Has the horse left the barn? Can you now do something that kind of quells all of that?
Well, I want to be fair, because last week I said that it was rich that the defense was concerned that the jury pool was being poisoned. And of course, this week it's rich that the prosecution has the same concern, because that's what lawyers do, right? Especially if there's a public trial like this. They try to get any potential jurors to already get information. This is a little bit different because Brennan is accusing this as a violation. Yannetti and the defense say that it was a mistake. But look, at your free speech rights, the First Amendment, the most important amendment we have, does have restrictions, and Karen Read getting a fair trial may require a gag order on her lawyers, indeed. So this is just something that the courts need to figure out which is more important here, the First Amendment rights or Karen Read's right to a fair trial, even if it seems to impact her defense.
Another issue for Judge Cannone to sort out before this next trial begins, scheduled to start on April 1st.
It could be
April
October.
1st.
You might be right.
Sue O'Connell,
we'll write that down.
Courtroom Insider. Thank you. That concludes today's edition of Canton Confidential. We will return tomorrow at 7. Until then, scan the QR code on your screen right now to catch our live blog from today's hearings, along with years of reporting on the Karen Read murder case. Again, the trial's set to start April 1st.